Okay, students, so now we are going to study the legal system of England and Wales. So, United Kingdom collectively is having three primary units. England and Wales is a separate country. Scotland is a separate country. Northern Ireland is a separate country. All these three countries have come together to form a single unit, which is called as the United Kingdom. United Kingdom is centrally governed through England and Wales. Now, United Kingdom is not having a written constitution. The governance over here is unitary in character. That is, there are no separate state governments. There are no separate legislatures for Ireland, or for that matter Northern Ireland, or for that matter Scotland or Wales. There is a central legislature called as the Parliament of Westminster, which is making laws for United Kingdom as a whole. However, of late you will find that certain lawmaking rights have been given to regional legislative bodies in Scotland and Northern Ireland, but it is in form of authority which has been delegated by the Parliament of UK, and Parliament of UK can theoretically it can take back that authority anytime. The regional legislatures, they can be put to an end anytime by the Parliament of UK. Parliament is the UK Parliament. It is basically having two houses: House of Commons, House of Lords. All right, and it is supreme lawmaking body of the country. Head of the state in UK is the monarch, that is the king, who comes to occupy that position due to his royal legacy. But right now his position is merely ceremonial in character. The real power is vested in the executive, which is headed by the Prime Minister and his Council of Ministers. Like India, they are also having a parliamentary form of governance, wherein Prime Minister and the Council of Ministers are also a member of the Parliament of UK. The government is basically exercising all the powers through the name of the monarch, and monarch is also responsible for his acts to the government. As I told you, UK Parliament is having two houses: House of Commons and House of Lords. House of Commons is a representative body. That means members of the House of Commons are directly elected by the people. The chairman of House of Commons is the Speaker. House of Lords is not an elected body. Most of the members of House of Lords, they are appointed to that particular house under a particular law called as Life Peerages Act of 1958. Once a person becomes member of House of Lords, he remains a member of House of Lords for his lifetime. Now, the members of the House of Lords, they are appointed by the monarch on advice tendered by Prime Minister and Appointments Commission. There is a Appointments Commission in UK. So, Appointments Commission plus Prime Minister plus the monarch, they together are appointing the members of House of Lords. As I told you, the executive branch, that is the government of UK, is made up of the monarch as the head, then Prime Minister plus his ministers and the civil servants. The legislative branch of the state is made up of the monarch, that is the king, plus House of Commons and House of Lords. Judicial branch is made up of, number one, monarch. He is head of judiciary as well. plus legally qualified judges and magistrates. An important amendment was made to the judicial system of UK. Changes were made in this judicial system of UK by way of Constitutional Reform Act 2005. Now, how are judges appointed in UK? Judges are appointed in UK by a Judicial Appointments Commission. This commission was established in 2006. So, an open competition is held in UK. Candidates appear in that open competition, and accordingly, whoever succeeds after going through a process is appointed as a judge. The commission is making those appointments on the advice which is given by Prime Minister and the Lord Chancellor. Now let us see what is the structure of courts in UK. UK is having civil courts and criminal courts. Also, it is having certain tribunals. So we are not going to look into the aspect of tribunals. We will focus on the structure of civil courts and criminal courts in England and Wales. We will not enter into the question of the court structure in Scotland or Ireland. We will focus on England and Wales. So let us see what is the structure of courts in England and Wales. So on the civil side, the lowest rung courts are the magistrate courts. Magistrate courts are basically dealing with issues like that of matrimony, child custody, child welfare, etc. Above the magistrate courts are county courts. Just like India is divided into various districts, UK is divided into, or England and Wales are divided into various counties. So for every county there is a county court. There are nearly about 160 county courts in UK. Above the county courts there is High Court of Justice, and on the civil side High Court of Justice is having three divisions: the King's Bench, the Chancery Division, and the Family Division. Above the High Court is Court of Appeal, Civil Division. So there is a Court of Appeal, and on the civil side it is having a Civil Division. And the topmost court of UK is Supreme Court, established in 2009. So I repeat once again the structure of civil courts in England. At the bottom is the magistrate courts, above it county courts, then High Court of Justice, King's Bench, Chancery Division, Family Division. These divisions are basically deciding civil cases. Then above High Court is Court of Appeal, Civil Division, which is going to hear appeals against the decisions of High Court, High Courts, King's Bench, Chancery Division, and Family Division. Topmost court is Supreme Court. So Supreme Court of England and Wales was established in 2009, and it is the topmost court for England and Wales plus Northern Ireland. Supreme Court is not dealing with any direct case. No case can be directly filed into the Supreme Court. Supreme Court is only hearing appeals which are coming from Court of Appeals. And the role of Supreme Court is very limited. It is only going to clarify law points which are in dispute. Facts are decided in the lower courts. Appeals are rarely made to the Supreme Court because most of the cases are settled at the level of Court of Appeals. Most of the cases are settled at the level of Court of Appeal. And the decisions of the Supreme Court, they are binding on all courts of UK. Below the Supreme Court is Court of Appeal, Civil Division on the civil side. It is the second highest court dealing with civil matters. Again, as the name appears, It is only dealing with appeals which are being made to it against the judgments of the High Court or the county courts. The civil division of Court of Appeal is headed by Master of Rolls. It hears appeals from county courts and the High Courts. It can change the decisions of High Court and county courts. It can hold the decisions of High Courts and county courts. It can also overturn the decisions of High Court and county courts when an appeal comes to it. Then there is High Court of Justice. On the civil side, it is having 3 divisions. First division is King's Bench. King's Bench is handling cases in concern of contract, torts, commerce and insurance. It also reviews the decisions of the government authorities in case a petition is filed to it. Then there is Chancery Division. Chancery Division is handling the cases in concern of trusts, company law, insolvency, intellectual property law and land law. Last is Family Division, which is handling the cases in concern of matrimony, divorce, child custody and guardianship. So High Court of Justice is having many divisions. Among those divisions, these 3 divisions are dealing with civil cases. These 3 divisions are King's Bench Division, Chancery Division and Family Division. Below the High Court is county courts. Most of the civil cases, they are arising in the county courts. There are about 170, previously I mentioned 160. There are about 170 county courts in the country. Most of the cases, they arise and they are settled by the county courts. Every county court is having a circuit judge. Now this circuit judge, when he is sitting in the county court, he decides civil matters. When he is sitting in the Crown's court, he is deciding criminal matters. Then every county court is having district judges who are full-time judges and who are basically handling bulk of the civil cases. Then the district judges are assisted by deputy district judges. These are part-time judges who are also barristers and attorneys, and they assist the district judges in making decisions. Also, over here there is jury system. That means 12 citizens, they are supposed to perform the task of a jury and they will decide the facts of the case. They will give their judgment on facts of the case and then the judge will apply the law and give the final judgment. Below the county courts are magistrate courts. The magistrate courts are basically magistrate courts are designed to deal with criminal matters, but they are also having a limited amount of civil jurisdiction. For example, in matters of child welfare and protection, in matters where alcohol license is supposed to be given, betting license is supposed to be given, or taxi license etc. is supposed to be given, or wherever taxation matters arise, where matters of public health are a concern, or tenancy matters, magistrate courts, which largely are dealing with criminal matters, they are having the jurisdiction to settle civil cases. This was all about the civil court structure in England. Coming to the structure of criminal courts. Now, the lowest ranked criminal courts in UK are the magistrate courts. Above it, the Crown courts. Above it, Court of Appeal, Criminal Division. And the top rank court again, Supreme Court. So Supreme Court of United Kingdom is the highest court of appeal for criminal cases in UK, as I told you, it does not conduct trials. It only hears appeals, and appeals on point of law, not on points of fact. Facts are already decided in the lower courts. So therefore it is going to hear cases only on points of law. Appeals are allowed to the Supreme Court only when a significant legal issue is involved. Below the Supreme Court, Court of Appeal Criminal Division. The Court of Appeal Criminal Division, again, it is also going to only hear appeals. It is not going to conduct any fresh trials. Now, these courts are basically headed by the Lord Chief Justice of England and Wales. Court of Appeal Criminal Division is headed by Lord Chief Justice of England and Wales. It deals with all the cases which are coming in appeal from the Crown's Court. All those cases wherein convictions have been made, all those cases wherein sentence has been given after conviction, and there is a issue regarding the appropriateness of sentence from either side, or those cases which have been sent by a reference by Criminal Cases Review Commission or Attorney General, and opinion is that there has been a miscarriage of justice in those cases. The Court of Appeal Criminal Division, it can uphold the decision with no change in conviction or sentence. It can quash the decision of the Crown's Court. It can order a retrial and send the case back to the Crown's Court, or it can change the sentence. It can increase, reduce, or alter the conditions of sentence. As I told you, it does not retry a case afresh. It only decides questions of laws. It usually does not interfere in questions of fact. Where it feels that questions of fact have not been decided properly, it sends the case back to the trial court, that is the Crown's Court. Now coming to Crown's Court, it is the second rung criminal court of the country, established in 1971. It is having circuit judges, then it is having recorder who are part-time judges, then it is having jury which is a body of 12 citizens who decide the facts. Now the Crown's Court is basically going to hear, number one, those cases which are indictable, that is, which are serious, and second, either way offences, that is, those which can be tried by both Crown's Court and the magistrate courts. It is also hearing appeals against the decisions of magistrate courts. So far as magistrate courts, below the Crown's Court there are magistrate courts. These are the entry level cases courts, and most of the criminal cases are filed before magistrate courts. Now they are presided over by lay magistrates, that is, those volunteers who do not have a qualification in law, that is, they are not having a law degree. Then they are also presided over by district judges who are fully trained, full-time professional judges. Magistrate courts, they can try those cases wherein punishment ranges from 6 months for a single offence. Where 2 or more offences are concerned, punishment is up to 12 months. They can also impose fine, they can also impose community service, they can also impose probation or compensation orders as a punishment. In case, for a particular case, the punishment that can be awarded is beyond their power, then they will refer that case to Crown's Court for a sentence. They will conduct the trial and then they will refer the case for sentence to the Crown's Court. This was all about the legal system of India.